what we can do. We're entitled to a hearing on damages and the ouster claim. I don't know if mediation is appropriate in this case or not. So I wish I could be more informative as to where we go from here. I frankly don't know.
Vic, any input from you on that?
Yes, Your Honor. Although there are a number of matters pending before different courts and different judges, I don't see how that's relevant to this particular action. We have already participated in mediation. Discovery was extended, I believe, twice at Mr. Blumberg's request. The deposition he wanted to conduct for the purpose of the last extension was conducted. No motions have been filed. I would ask the court to set this on the trial docket so it can be resolved. We have offered different options of settlement and have it's went nowhere. So
all right. Did either of you make a jury? I don't think this is something that would be triable in front of a jury, right? I mean, this is going to be a bench trial.
No,
correct.
Judge. No, that's incorrect. The partition action is an equitable action. The ouster claim is a damage claim that can be properly brought before a jury.
Your Honor,
Right.
I don't believe a jury demand was ever filed.
Yeah, I don't see a jury demand in here. So, yeah, without either side having demanded a jury, the court would set this as a bench trial as to both issues. So, yeah, I'm going to get this on the docket for a bench trial so that we can get it resolved. And the parties are free to continue negotiating if they would like. But there's no sense in, everybody putting off different cases and waiting for other cases to get resolved. So for whatever reason, both Mr. Ruttkamp and Ms. Godiva have both undertaken the actions they've taken and filed what they've filed in all the different jurisdictions in which they've filed them. And I'm not going to try and wait for other things to work themselves out. So Mr. Blumberg, how much time would you need to be ready for the court to set this?
Given my current trial schedule, I would say at least 30 to 45 days.
And how much time do you think I would need to set aside for the evidentiary hearing in this?
I would think a minimum of a single day.
Okay, Ms. Bailey, quick.
I likewise agree. I didn't anticipate the court would be able to get it likely on the July docket. We're ready, however, and I believe it would also be a 1 day.
Okay, so I'm going to set it for a 1 day bench trial. I don't think I can get it on in July, so I'm going to set it for 60 to 90 days out. I will put in the status conference order that the parties are to exchange final witness and exhibit lists 14 days prior to the hearing, and to submit to the court trial briefs also 14 days prior to the hearing. Mr. Blumberg, are there any other dates or deadlines that you would like the court to include in this order?
I cannot think of any. Thank you.
Okay, Ms. Bailey, quick.
I don't have anything else to add to that. I do, however, have a question. When it comes to the witness and exhibit list, does the court want exhibits exchanged between the parties and provided to the court in advance of 14 days, or just the list to the court and the exhibits exchanged between the parties?
What I'm talking about is just disclosure. If the two of you want to, meet and confer about exhibits and try to agree to any stipulated exhibits ahead of the trial date, that certainly would make things go smoother. But in terms of what the court is going to order, I'm simply going to order the disclosure of what witnesses each of you actually intends to call, and a list of exhibits to exchange so that both of you are on notice of what each of you are intending to introduce, both in the form of testimony and documentary exhibits at the trial. Of course, either of you will have full opportunity through the course of that and at the time that they're presented for admission into evidence to object to any exhibits or witnesses, but I think we would need to address it on the record at the time that they are put forward for admission. So I'm just talking about disclosure, again, to the extent that the two of you think that there are exhibits that could be stipulated to make things go quicker. That would not only save the court time, but of course save your client's time and money if it doesn't take a full day to present the evidence. So.
Very good, thank you.
Yeah, does that answer your question?
It does.
Okay. Okay, that's all I have then. I'm going to put what we've discussed today into a status conference order. I will send that out to the parties, and then the court will send out notice of the date and time for the evidentiary hearing in this case. And we'll go forward at that date. And that's all I have. Both parties are free to disconnect. Thank you.
Thank you.
Just come to payment.
Yeah. Heard that one already today.
Give us a year.
All right, looks like we have both counsel connected, so we'll go on the record in Shaw versus Stiles. This is file number 2311441. If I could have both counsel put your appearances on, please.
Yes, good afternoon, Your Honor. Charles Soon on behalf of the plaintiff.
William Carey appearing on behalf of the defendant counter plaintiffs, Your Honor.
All right, this is set for a status conference today. The last time we talked was back in March. The court left discovery open for an additional 90 days and then set the hearing for today's date. Mr. Hewitt, can you give me an update on where things are at least from your side?
Yes, Your Honor, I'd be happy to. Yeah, the court indulged us. We're thankful for that because our respective clients had several health issues we had to get by. We've taken depositions of the principal parties that took place last week of April, if I recall. And that's where we're at. And we're just waiting to have our conference here today with you. I'll have Mr. Carey add whatever he thinks needs to be added.
Yeah, we were successful in completing depositions on both sides, and we've since exchanged certain ideas by way of a resolution of the case. We haven't reached a resolution of the case, and I don't, on behalf of my clients, require any further discovery. The case has already been mediated, so I think we're probably as far along as we can be without having a trial date.
I think Mr. Carey answered my question. Was he going to surprise us with an acceptance of a proposal? But that's okay.
All right, there has not been a jury demand here, correct? This would be tried before the bench based on the
Right.
claim.
Yep.
That's correct.
Mr. Hewitt, how much time do you want to have before the court sets this for a date?
I don't have any pressing trips or anything between now and December. I have some other recreational matters taking place before August, but I didn't know how soon the court was going to be scheduling this in any event. Mr. Shaw doesn't have any trips between now and the end of the year either. I checked with them this morning.
All right, I mean, I think I would be looking at probably September before I could get a date for this, so.
That's what I kind of figured. September is fine with us both, Jim, yes.
All right, Mr. Carey, does that give you enough time to prepare as well?
Yeah, if we can fall into a December date, that would work best for me as well. I do have a couple trips planned first half of October and substantial part of November. So if we could get it in September, that'd be fantastic.
Oh, okay.
Okay. All right, and then how many days should I set this for? Can we get this done in one day, or are we gonna need more than that?
Oh, Mr. Carey and I have had a trial in the past, which I think involved more issues and more witnesses, and we got it done in a day. I would think a day, quite seriously.
I
I
can,
don't belabor issues as a matter of practice.
Mr. Carey, would you agree with that time frame? Sorry.
no, I do agree with that time frame estimate.
Okay, so I'm going to put in the order that the court will set this for a one-day bench trial in September, if possible. Is this the kind of case where the two of you think, like, if you met ahead of time, that you would be able to agree on some stipulated exhibits, or is there going to be, just trying to get a sense of how much we can take care of ahead of time here to save time during the trial?
There's definitely a base set of exhibits that we'll both want to use to present our claims. So for sure, we can agree on those, and Mr. Hewitt and I work very well together and won't have a problem doing that. There are probably some written communications, text messages, things of that nature that might rise to a higher level of scrutiny that we might not agree on. But I think the base set of exhibits we can probably stipulate to and use as joint exhibits.
I would agree.
Okay, so what I'm gonna put in the order here is that the parties will meet and confer on stipulated exhibits and submit to the court 14 days prior to the trial date.
Good.
And then I'm also gonna put in there that the parties are to exchange final witness lists also 14 days prior to trial. And that the parties submit, along with the stipulated exhibits, each of you submit a trial brief 14 days prior to trial.
Sure.
How much more do you really want to read about prescription and adverse possession, Judge?
Well, the judge probably hasn't read any material from me, Mr. Carey, so he probably wants to see how well I write. And
It's one of my favorite areas of the law, so I love reading about it. So
Fair enough.
I do more than enough, criminal and family law. It's nice to get a good, solid property issue every now and then. So,
Amen.
Okay, Mr. Hewitt, any other scheduling dates or deadlines that you want me to set today?
No, I'm fine. If something comes up, I'd be surprised if I couldn't work it out with Mr. Carey.
Me too. Vice versa.
All right. Okay, very good. So I'll just put what we discussed today into an order. I'll get that out to the parties, and then along with that order will be the date for that bench trial. And that's all I have. Both sides are free to disconnect. Thank you.
Thanks, Judge. Thanks, Chuck.
Thanks, Bill. Take care.
How come I can't disconnect?
Worst case, is that a default?
Yes.
So if one party's connected, wait.
Yeah, apparently he called, he had heard.
Hold on a second. All right, ma'am, can you tell me your name, please?
Michaela Des Moines?
Kayla Des Moines. Okay, and sir, are you Robert Des Moines?
Yes, sir.
All right, we're on the record today in file number 2511851, Des Moines versus Des Moines. Both parties are present by Zoom video here today. I have this set for entry of a judgment of divorce. Ms. Des Moines, is that how you wanted to proceed today?
Yes.
And Mr. Des Moines, is that how you wanted to proceed as well?
Yes.
Okay. I'm going to ask that both of you raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Yes.
Thank you. You can both lower your hands. I need to ask each of you some questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Des Moines, because you were the party who filed in this case, most of my questions will be for you to start with. You filed this complaint for divorce and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
No.
Okay. Mr. Des Moines, had you been a resident of Michigan for at least 180 days?
Yeah.
Had you been a resident of Crawford County for at least 10 days?
Yes.
Okay, all right, thank you. Ms. Des Moines, in your complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that your marriage could be preserved. Was that true when you filed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under this divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Are there any issues regarding the division of any assets or debts of the marriage that remain for the court to decide?
No.
And do you own any real estate or real property together with Mr. Des Moines?
No.
Thank you. Mr. Des Moines, have you heard all the questions that I asked Ms. Des Moines?
Yes.
Did you hear all of her answers?
Yes, I did.
Do you have any reason to believe that any of the answers that she gave were untrue?
They're true.
Okay. And do you agree that there are no issues regarding the assets or debts of the marriage for the court to decide?
I agree.
And you understand that you could not come back later and ask the court for spousal support or alimony?
Yes.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties in this case. The court will grant the divorce. I've signed the judgment. Ms. Des Moines, you're asking to have your last name changed, is that correct?
Yes.
So from today forward, your last name will be changed legally, so you're going to need to change your identification and other documentation. If you need a copy of the judgment of divorce, in order to do that, you can contact the clerk's office here in Crawford County, okay?
Okay.
Do you have any questions at all, Ms. Des Moines?
No.
Mr. Des Moines, do you have any questions?
No.
Thank you. That's all for today's hearing. Your divorce is final and you're both free to disconnect at this time.
Thank you.
Thank you.
I think we've got all the counsel connected that we need, so we'll go on the record in Hamel versus Munson, file number 21-11065. And if I could just have counsel put your appearances on, starting with plaintiff, please.
Good morning, or good afternoon, Your Honor. Albert Dibb appearing on behalf of the plaintiffs.
David Busker on behalf of the Munson defendants.
Enrico Tutoroni, I'm appearing on behalf of Keith Eaton with Lauren Rhodes. She's here with me today.
Justin Hackle on behalf of Dr. Atchison. Good afternoon, Your Honor.
Okay, good afternoon. We're on the record today for status conference. So I was reviewing the file prior to the hearing today and going through my notes as well of our last few hearings to kind of refamiliarize myself with the case. And so I noticed there was a discrepancy in my notes from our last hearing, which was in January, and what the ROA shows, and I'm certain that the ROA is correct, that there is still an outstanding opinion that the parties are waiting for from the court arising out of that last hearing. And I had in my notes that I had ruled from the bench on all issues, but obviously I owe the parties an opinion. I've already started working on that. So I'm going to get that to the parties as soon as possible, realizing that that is, okay, can I have you take the child out of the courtroom? It's probably not important, not appropriate to have a small child in here for this kind of hearing you guys are going to have anyway, so. Sorry about that, folks. Counsel, I've got another hearing waiting here in the courtroom. So anyway, as I was saying, the court's going to get that opinion since that is overdue to the parties. I would like to see how the parties want to go forward and whether or not, you know, at this point we need to get trial dates on the calendar and where the parties are at in terms of going forward. So I guess, Mr. Dibb, I'll ask you to address that first from the plaintiff's side. What is your view of the status right now, and what would you like to request today in terms of scheduling going forward?
I think everything's been completed, Your Honor, with the exception of the opinion that you alluded to. I think all the discovery is done and the parties are ready to go to trial. So I'd ask for a trial date. I've got my trial calendar with me. So I would ask that if you could give us a date that would be convenient to everyone.
Okay, Mr. Busker, can you tell me from your standpoint on behalf of your clients how you would like to proceed?
Your Honor, that's our understanding as well. As far as we know, we've deposed all plaintiffs' experts that will be testifying at trial. Plaintiffs' counsel's deposed everyone he intends to depose. To our knowledge, there is an interest in further facilitation, and we're also ready for trial dates once we have those opinions. You know, unless those opinions lead to some other issue. I'm not sure if the court's going to allow it, you know, as far as an updated report or different experts. I know some of those requests were that experts be stricken, that reports be stricken. So in part, it will depend on what happens in those opinions. But other than that, it's my understanding that we're also ready for a trial date.
All right, thank you. Mr. Tucciaroni?
I would agree with Mr. Busker on that, on that, Your Honor.
Okay,
I
Mr.
think once we
Hackla?
get the decision.
Oh, sorry.
I'm sorry. I think once we get the decision on the economic damage motions, then yeah, we're ready to roll.
Same here, Your Honor.
Okay, all right. So I think we can go ahead and get the trial, at least some trial dates on the calendar. If the opinion ends up changing, you know, anything about that, I think there'll be plenty of time between now and when the trial would actually happen to address any issues that could arise. Mr. Dibb, and just so all counsel's aware, I typically don't schedule from the bench. What I try to get from counsel is an estimate of how much time you all want to be ready. or need to get ready, and then how many days of trial that we'll need. And then the court will schedule the trial based on that. So with that in mind, Mr. Dibb, between today's date, or starting with today's date, how much time would you want before the court schedules this for trial? How many months would you need to be ready to start trial?
So in looking at my trial calendar, Your Honor, I'm pretty much February, March, April. I'm pretty much booked through April of next year.
Okay, so you're looking at a May date of 2026?
Yes, sir.
Okay. Defense counsel, sorry, go ahead.
I'm sorry, Your Honor. I've got a trial September 8th, two of them in November 12th and November 24th. Three of them in December 1st, 8th, and 15th. Another one January 6th and January 12th. And one February 2nd, March 2nd, and April 14th.
All right, and Mr. Dibb, how many days of trial do you think it would take to try the whole case? And I understand that I'm asking you to estimate defense side, but I'm just looking for, and I'll ask the defense counsel this as well, but how many days of trial do you think the court would need to set aside in total?
Well, is 14 days too much? Taking into account the number of defendants, the experts that'll be called on behalf of each defendant, plaintiff's experts. I don't think 14 days would be unreasonable.
Okay. All right, thank you. First of all, in terms of the time frame of next April, are there any defense counsel that has an objection to that as a time frame?
None whatsoever, Judge.
You said April, Judge, but I think, did Mr. Dibb say April or May?
April.
Okay, April. I'm sorry, I was looking at the wrong month. Your Honor, from my standpoint, there is nothing in April that would bump a trial in this case. This would be the oldest thing, and the other stuff I've got is not going to be an issue. So,
Me either, Judge.
Same, Your Honor.
Okay, and then in terms of if we set it for 2 trial weeks, defense counsel, do any of you think that would not be enough time?
Your Honor, my estimate would have been 3 weeks. There's 5 different standards of care here still at issue. That's 10 experts, most of whom are out of state, just for the standard of care questions, just to have a plaintiff's expert and a defense expert for each. There's some pretty significant causation and damages experts we'd expect as well. To the extent it impacts timing, none of the defense experts have been deposed in the case, so that may impact how quickly their testimony or cross-examination can happen at trial as well. So I was expecting more like 15 days for trial.
Okay. Mr. Hackler or Mr. Tucherone, and either of you agree with that? I disagree with that or object to that as a duration estimate?
I don't object to that, Your Honor. I think it probably is somewhere between 2 and 3 weeks, just based upon the number of witnesses and experts. Although my proofs would be, I'm kind of on the tail end of this. I have an ER doctor who did made resuscitation attempts, so I have him and 2, maybe 3 experts.
Okay.
So
all right. So what I'm going to look at,
day and a half.
Okay. All right. I think we have enough time. I'm fairly confident that the court has not scheduled any dates that far out yet. So I'm going to look at setting this for 3 weeks in April of 2026. The court will send out a notice of those trial dates to all parties following this hearing. I will issue the opinions that are outstanding as to I believe there's 2 opinions that are outstanding that arose out of those motion hearings. And the court will issue those as soon as possible. And then along with those, as I indicated at the time of our last hearing, I will send out another status conference order following the issuance of those opinions. It'll be sufficiently after the court issues those opinions for all counsel to go through that, discuss with your clients the effect, if any, that that would have. And then at that status conference, we can set any further deadlines that we need to set as we get closer to trial in terms of motion cutoffs and all of those types of things. Mr. Dibb, do you have any objection to that as a plan going forward?
No, Your Honor, but I did mention that the last trial I have is April 14th, 2026, and I think the court recognized that and was looking at a May date.
Okay, right, sorry. So yes, May of 2026 then.
Thank you.
Other than that, Mr. Dibb, any objection to that as
No,
a plan for going forward?
A good plan. Thank you.
Thank you, Mr. Busker.
No, my only question was whether those trial dates, motion in limine, jury instructions, things like that, if a separate order would be issued about those due dates.
Yeah, so at that status conference, I want to just touch base with the parties about the effect, if any, of the court's opinions. And then after that status conference, typically, especially in a trial like this, medical malpractice with as complex as the trial is likely to be, I set what I call a trial preparation conference with all counsel, either 30 or 60 days prior to the trial date, where we can discuss all the kind of procedural nuts and bolts of the trial.
Okay.
Mr. Mr. Hackla, any objection to that as a plan for going forward?
No, Your Honor, that sounds reasonable.
Mr. Tucherone?
No, Your Honor. Sounds like a good plan.
All right, and I just want to confirm with counsel that the court would be setting this for a jury trial, Mr. Dibb, is that correct?
Yes, sir.
Defense counsel, is that all your understanding as well?
Yes, sir.
It is.
Okay. Okay, thank you. So the court will send out notice of the trial dates. I will again issue those opinions, along with those opinions, a status conference order and a date for that. And we'll go forward from there. I'll also issue a status conference order arising out of this hearing today, just reflecting what we've discussed, and get that out to the parties. That's all I have for today, and all counsel are free to disconnect at this time. Thank you.
Thank you.
Your Honor.
Thank you, Your Honor.
Okay, we're on the record now in JP Morgan Chase Bank versus Reed. This is file number 2511872. Ms. Massey, you're appearing on behalf of plaintiff, is that correct?
I'm on
Okay.
behalf of defendant Annalee Reed.
Okay, on behalf of defendant.
Yes.
Have you had any contacts with plaintiff's counsel in this case?
No, other than sending them notice of my appearance and answer at the beginning, I've had no other contact.
All right, for the record, this hearing was set for 2:45. It's now 3:10. Plaintiff's counsel nor plaintiff has appeared. It was set by Zoom, but they're not here in the courtroom either. So Ms. Massey, I'm not sure how you want to proceed. I can set this for one more hearing, but I'm open to any record you'd like to make in terms of how you'd like to proceed in light of their non-appearance here today.
Your Honor, I'd request that the case be dismissed.
All right, I am going to set this for one additional pretrial conference. And if if the plaintiff does not appear at that next conference, then the court will grant your request to dismiss. And the court will note, of course, again, for the record, that they did not appear today. So the court will send out notice of the date and time of that hearing. And we'll proceed further on that date. Ms. Massey, anything else that you'd like to say for the record today?
No, Your Honor, thank you.
Okay, all right. Obviously, Ms. Massey, if the other party does not have an adequate basis for failing to appear today for some kind of reasonable excuse, the court would also be open to, request for costs or attorney fees on behalf for you appearing today on behalf of your client. But I think that's something we would have to address at the next hearing.
Okay, thank you, Your Honor.
Okay, you're free to disconnect at this time.
Thank you. Have a great day.
Thank you. And are you Candy Schultz? Okay, I'm gonna have you come up to that chair there, and we have Clayton DeKreutzer. Not unless you're an attorney. All right, on the record in Schultz versus, how do you pronounce your last name, sir?
Kreutzer.
Schultz versus Kreutzer, case number 2511896. The record should reflect